Well, Mark did a fantastic job, and I fear I'm going to be repeating a lot of what he said. But that's okay. We'll repeat it in a different way and hopefully add a little bit of color to his testimony. I'm the National Communications Director for the 10th Amendment Center. Our organization has been involved in this particular issue really from the beginning and worked very closely with the legislatures in California, Virginia, and Alaska in helping them get this legislation passed. It's something that's very important to us, and I think what Pennsylvania does helps add the momentum and can have not only an impact here in the state, but also across the United States. Now, SB999 is really pretty simple in function. What it essentially does is it prohibits the state of Pennsylvania from participating in or cooperating with federal kidnapping. Now, some people might balk at me using the word kidnapping, but sections 1021 and 1022 of the NDAA purport to allow the federal government to pick people up, hold them indefinitely without charge and without due process. To me, that's the very definition of kidnapping. I think it's very, very important that we move forward with this bill. Even though I'm sure many people are skeptical of the fact that these provisions actually exist in the NDAA. After all, Congressmen have told us that this isn't what it does, and they've assured us that it does not apply to American citizens. But the fact of the matter is, if you read sections 1021 and 1022 of the NDAA, you will find that the language is very, very vague. And it's actually been subject to a great deal of debate at very high intellectual levels, much higher than mine for sure. And I think that in and of itself should cause a great deal of concern, because we all know that when there is vague language, it is almost always construed as broadly as possible in application. But the fact of the matter is, the language itself does seem to indicate that it authorizes indefinite detention. You don't have to take my word for it. In early 2012, a group of journalists and activists sued the federal government. And their argument was essentially that their activities as journalists and as political activists could conceivably subject them to military detention. Now, it's very, very telling that when Judge Catherine Forrest questioned government lawyers and asked them directly, can you assure the court that these people's activities will not subject them to indefinite detention, the federal government lawyers would not make that assurance. She wrote this in her opinion: the government did not and does not generally agree or anywhere argue that activities protected by the First Amendment could not subject an individual to indefinite military detention under sections 1021b2. She went on and ruled these particular sections unconstitutional. I think it's very important to read her words, because this is a federal district judge. She said, a key question throughout these proceedings has been, however, precisely what the statute means, what and whose activities it is meant to cover. That is no small question bandied about amongst lawyers and a judge steeped in arcane questions of constitutional law. It is a question of defining an individual's core liberties. The due process rights guaranteed by the Fifth Amendment require that an individual understands what conduct might subject him or her to criminal or civil penalties. Here, the stakes get no higher. Indefinite military detention, potential detention during a war on terrorism that is not expected to end in the foreseeable future, if ever. The Constitution requires specificity, and that specificity is absent from sections 1021b2. She wrote, the statute's vagueness falls short of what the due process requires. So it's pretty clear that the federal government could conceivably use these sections in the NDAA to authorize indefinite detention. It's even more concerning to me when we realize that there's actual evidence that things such as protesting war or having, quote, anti-government attitudes, whatever that might happen to mean, could land somebody on a terrorist watch list. When you put things in those terms, these provisions become even more chilling. So the question today before us isn't really whether or not, the question before us today is actually whether or not Pennsylvania can do something, can refuse to cooperate with these provisions. And the answer is absolutely yes. There is absolutely nothing that says that the state of Pennsylvania has to cooperate with the federal government as it violates your rights. As Mark mentioned, Under a legal doctrine known as the anti-commandeering doctrine, it is well established that the federal government cannot require a state to utilize its resources or agencies to enforce or implement a federal act or program. This was actually first established in the court case that Mark mentioned, Creek versus Pennsylvania, right here in Pennsylvania. Justice Story did indeed argue and give the opinion that the state of Pennsylvania could not be required to help the federal government enforce the fugitive slave laws. It was a federal law, the federal government was obligated to enforce it on its own. Over the years, several other Supreme Court cases have built upon this, creating what we now call the anti-commandeering doctrine. And probably the most important case is Prince versus U.S., which was heard in 1996, and was actually a gun case involving the Brady gun bill. Justice Scalia wrote in the majority opinion, the federal government may neither issue directives requiring the states to address particular problems, nor command the state officers or those of their political subdivision to administer or enforce a federal regulatory program. It matters not whether policymaking is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. So the question isn't whether or not the state of Pennsylvania can refuse to cooperate or assist in indefinite detention. That's a substantive question. The question is, will Pennsylvania take this step? Do we care enough about due process, the Constitution, and basic civil liberties to say we will not aid and abet federal kidnapping?